Good. Hello, Jim.
Hi.
Oh, I better plug in my microphone. The sound will be better.
You didn't play any noise with that microphone.
Okay. All right, how's that? Ah, it looks pretty good. Okay. All right. Oh, that's not right. It's this one there. Good. And this one. Oh, good. I see Rachel's here. Good. All right. So there's the schedule. Anyway, I guess what I usually do when I have time to fill like this is look at the news. So I think I'll do that while we wait. Because I know there were 9 people last time, and I imagine a few more are going to show up. Let's see if there's anything fun in the news. This might be good. Well, there's a few fun things. Oh, here comes something. What's this? Oh, that's for YouTube. Probably not. Yeah. All right. So this is pretty good. Outlook for a while has been sending you encrypted emails with a second copy of the plain text email in each message with S-MIME. So that's pretty harsh. This is step 1 in cryptography, is check for plain text. It is very common that cryptographic systems are broken and actually don't encrypt things. This is coming back again. It just keeps coming back like a bad penny. There are companies that will sell you a service that will hack people that hack you. There are automatic firewalls that do it. There are people you can hire that will do it. And it just, everybody I know with any sense thinks this is nuts. Because if you attack somebody over the internet that you think is hacking you, you just get innocent victims, generally. But anyway, it's back again. They're starting to pass a law so you can hack people who hack you. I doubt it's really going to become law, but we'll see. Steve Wozniak is going to launch his own online platform, and it's going to have physical locations for colleges. So this may turn out to be important to we college teachers. It may be competition or a job opportunity or something. Right now, he's put out an app, but it just has some kind of preview without much information. But there may be something important in education coming out of that. Let's see what else might be fun. This one was fun. one's interesting. I suppose everyone knows about that one. Let's see. Here's a few more fun ones. So I imagine you know Kaspersky is now officially forbidden for government computers and I think military ones. And the evidence seems really damning. The Israelis hacked into Kaspersky's network and found that they are in fact stealing the NSA secrets with it. And the NSA attacks I've been using in my advanced hacking class, Eternal Blue and Eternal Romance, were stolen this way. The antivirus has the ability to scan every file on your computer and send copies of it back to Russia as part of its normal antivirus behavior. So it's a fine espionage tool. And the only unclear thing is whether Kaspersky allowed the KGB to do this, or the KGB hacked them the way the NSA hacks all the American companies. But it doesn't really make a difference for the final answer, which is that if you're involved in U.S. government or military secrets, you shouldn't have Kaspersky on your machine. So anyway, let's see what else is here. I'm getting stuff in my way. All right. So this one, the Google Home Mini thing that listens to you, like I think the Alexa, has a bug which caused it to record everything you said in the room and send it back to Google. This is something privacy advocates worried about when people first started putting these audio sensitive devices in the room, but quickly people seem to forget about that. I know they got all upset when intelligent Barbie dolls were taking everything your children said to it and sending it up to the internet and recording it. So it is very strange. Now we are all carrying location sensors in the form of cell phones, and now we're putting bugs in the form of microphones in our house. So the government doesn't know everything, but companies like Google know everything. Anyway, on it goes. The DEF CON voting machine hacking report came out. We just got a voting machine in our hacking lab here, and DEF CON has a report here that's very good fun, explaining all the models they tested and how they hacked into them. They found that the amateurs were able to hack into every form of voting machine within a day or two, which shouldn't be much of a surprise to anybody that's looked at voting machine security. They are very insecure, and voting should really be done on a piece of paper with a pen. It is a very bad place to use a computer. 6:02, I think I better wait a few more minutes. This guy did not hack a computer, but he gave a password to somebody else who then hacked a computer. So he is convicted of violating the Computer Fraud and Abuse Act, which we're going to talk about a little bit tonight. And the technical people are mad that he is accused of hacking without exactly hacking. Maybe they'd be happier if he was convicted of conspiracy. But technically, he facilitated the hacking of a computer, and that turns out to be hacking in the eyes of the law. And the Australian doesn't want me to see this. All right. This one's kind of fun. So Intel is making a quantum computing chip. It is not very clear what it does. It's not a real quantum computer. It's one component showing some features of quantum computation, but it has to be cooled to millikelvins, which is very expensive. And then it's not quite clear what it does. So it's, like I say, I don't think anybody anticipates a real quantum computer that you can afford that will do anything for at least 10 to 20 years. But a few of the components are available in a very early prototype form that run at ridiculously low temperatures and are very difficult and expensive to operate. But quantum computers are coming. And when they come, RSA will fall, the encryption scheme. The Department of Justice, the FBI, wants to be able to send search warrants to companies and get plain text data, and they are very upset with companies like Apple that encrypt things so severely that they lock their own company out of the devices. It was until the last, about 2 versions back of the iPhone, you could take your phone to Apple, and if you forgot your password, they could get in because they had a secret backdoor. And they appear to have taken that out, and the government is trying to get them to put it back, saying, why do you lock yourself out of your phone? And a lot of technical and security people are trying to say this is impossible. The justice officials are saying, why should it be impossible? And, I posted a public statement kind of agreeing with them, saying, you could have a key split in half with key escrow. There are techniques available to have a key when under the right circumstances that shouldn't be easily stolen, but we will see what comes of it all. The previous attempts of the government to limit encryption have been very disturbing and led to very bad security for us all. So that's made a lot of people think we just should have the maximum possible encryption all the time and lock the government out of everything. And we will see how this all comes out. We're having that battle. Anyway, it's 5 after. I'm beginning to think we may not be getting anybody else. So I'm going to just go on to the chapter here. Does anybody have any questions or anything? I haven't muted you. You could speak up with a microphone, or you could send a chat or anything. You can do that all along. The chats pop up and I see them. The Zoom chat. So, all right, let's just start with the chapter here. So, we're down to the second part of this chapter 2. So, where it's legal and regulatory issues. And all right, I guess that thing will be all right. So, here's the major legal systems of the world. I'm going to try putting this thing at the bottom, see if it gets out of the way. All right. The United States uses common law, like Canada and Britain, and in common law, the precedent is set by other legal decisions, which is a particular peculiarity of it. Civil law is another alternative where precedents matter less, but it's not the system used in the United States. Then there's religious law in Islamic countries, which we also don't use, and customary law, which we don't use very much, except in the form of best practices. We talked last time about the issue of gross negligence. If you do something like Equifax, and you have some data and you lose it, then you're going to be hauled before regulatory bodies, and they will ask, were you doing whatever is customary to protect that data? Are you like the other companies in your business, or are you much worse than them? And that's a large portion of deciding whether you were negligent or not. So criminal law is where the police enforce the law, even if there is no victim complaining, for things like murder. And when you're caught, you go to prison typically, and proof must be beyond a reasonable doubt because the punishment is so severe. Civil law is less important matters, just having to do with money typically. The end result is typically just damages paid to the victim, and the burden of proof is just preponderance of the evidence. You just have, they call it 51%, or you just have to be more likely than not, and they will rule against you, and you have to pay a fine or a punishment of some sort in terms of money. There are 3 kinds of money you pay. Compensatory is the most obvious kind. If you cost some victim money, then you have to pay compensatory damages equal to the money that they lost. Statutory damages are damages paid just because you broke the law, even if you didn't actually cause any harm. And punitive damages are extra damages added just to make you suffer, to try to stop you or other people in the same position from doing it again. And then there's administrative law, which is where you pass regulations of some sort, and then you punish companies just for not obeying the regulations. I heard a guy on NPR who was a farmer, and he was very upset about genetically modified wheat getting in his field. And he said, you cannot take someone to court when you find genetically modified wheat in your field because you cannot prove that it came from the field next door. So what you do is you go to court and pass some kind of administrative regulation passed that says there must be a 100-foot gap between 2 fields to separate them out or something, and then you punish them for not obeying that rule because you can prove they didn't obey the rule, even though you cannot prove, for example, that this water pollution caused these people to get cancer. Anyway, that's the game. So in our business, it's typically HIPAA and regulations like that. There's also Federal Communication Commission and all these other agencies passing regulations that apply to businesses and the internet, and that's administrative law. So you have liabilities. If you break any of these laws, due care is also duty of care. We talked about that before. That is the prudent man rule, where you do what a prudent man would do. And then there's due diligence, where management checks to make sure that their employees are in fact practicing due care. All right. Evidence comes in various kinds. Real evidence is what you mostly want. You want when in court they bring the actual computer used to do something, the actual hard drive, the actual piece of paper, the actual murder weapon, not a copy of it or a photograph of it. That's real evidence. Direct evidence is witnesses testifying about what they saw themselves, which has great weight in court. And indirect evidence is circumstantial evidence that just shows that somebody could not account for their time or they were nearby when the crime took place, and that is often inadequate for conviction itself. Corroborative evidence is evidence that supports something else. Hearsay is normally inadmissible, which is something that the witness did not observe directly, but they heard someone else talk about. There has been quite an issue as whether computer records, like logs on a server, are hearsay or not. And in general, the conclusion has been that automatically generated business records are taken more seriously than hearsay in court. Best evidence is original documents. Secondary evidence is copies of documents. And log files can be considered in either category depending on the details. In computer forensics, when you take computer evidence to court, you typically put a hash value on it so that it is easy to verify that copies of it are 100% complete. Typically, they use the MD5 or the SHA-1 hash. One could say that both of those have been compromised to some extent now. We really should be using SHA-2 hashes, but in practice, there's not much to worry about with any of them. The chain of custody is a piece of paper with names on it and dates, so that these people have taken responsibility for protecting the evidence, and they are swearing that I took this object, I locked it in some safe place like a safe or an evidence room, and I made sure that nobody tampered with it until some later time when I handed it off to someone else whose name is also here. And if there is some dispute about the integrity of the evidence, these people can go to court and testify to back up their statement that this evidence has not been altered from the time it was seized by the police to the time it went to court. If you do not have an unbroken chain of evidence, then the value of the evidence is greatly degraded. This happened in the O.J. Simpson case. There was a glove, and they were unable to, I think it was a glove, they didn't have an unbroken chain of custody, and so it weakened their case. If your company wants to search company computers, they can do that without any particular legal process because they are company property. They're not the property of employees using them. However, if the government wants to search anything, they have to go through these procedures because the Constitution specifically limits the power of the government to search people. So when the cops or the FBI or anyone wants to search your stuff, the Fourth Amendment says they cannot have an unreasonable search. And so in practice, that usually means they have to have probable cause and go to a judge and get a search warrant. Otherwise, they are likely to find that the evidence will not be admitted in court. There are exceptions, however. Objects in plain sight in a public area, they can grab and testify about without a search warrant at a public checkpoint when you're crossing a border, and in exigent circumstances, when it is some sort of emergency, they are allowed to proceed without a search warrant, and they may be able to have that evidence applicable in court. If one difficult situation comes if you have someone like a server administrator at your company, and then they find something and talk to the police or the FBI, and they say, why don't you go find out more about that and give it to us? Now, your private individual employed by the company is acting as an agent of law enforcement. And now the Fourth Amendment might apply, because now it's not just the company investigating something, they're cooperating and somehow working with the police, so you could end up getting in trouble that way. This is why most companies prefer not to involve law enforcement with their investigations. You usually don't need to. If your own employees are doing something bad, you can usually punish them without needing the courts, which are doing things like firing them and cutting their pay and stuff like that. Only in the most extreme circumstances would you really need the police to come lock them up. And companies usually try to avoid that because they don't want the bad public relations. So that's an issue. Most companies would rather not go to court, then they do not have to bother with the rules of evidence. They don't have the secondary damage If all the company is doing is something that's causing you to lose money, like stealing money from the company, you can often just resolve that to your own satisfaction without involving the courts. Another issue, if law enforcement is involved, is entrapment and enticement. This does not seem to be effective for computer crimes. I know a lot of FBI stings in 2011 or 2012, when they got most of the hackers, involved setting up situations and luring them in, and no one seems to have succeeded in getting away with the crimes claiming they were entrapped or enticed. But at least under some circumstances, these are defenses. So computers can be involved in crime many ways. Computers can be the target. Denial of service, spreading malware. The computer can be a tool used to commit the same old crimes as ever, like stealing credit card numbers from a computer instead of stealing them from paper records or the trash. It amounts to the same old crime. The computer is just the latest tool used for it. And of course, all the online harassment and espionage. In general, if you use a computer network to do a crime, it becomes very difficult to prove who actually did the crime, and that's called attribution. And it is a very hot topic. People are still arguing over North Korea. Did they really hack Sony, or was it somebody else? Did the Russians really hack the DNC, or was it somebody else? And the evidence is hard to make conclusive for that kind of attribution. If you have data on your computer that you don't want stolen, it can be in a variety of categories. There's trademarks, which is your name or logo. Then there's patented inventions, where you have a period of time where no one else is allowed to use your invention. And then you have copyrights, where people are not allowed to make copies of what you do, except for something called fair sale and fair use. Then there are things like end-user license agreements. People who use proprietary software have agreed to use it only in certain ways. And then there are trade secrets. And these are protected by non-disclosure agreements or non-compete agreements. California does not allow non-compete agreements, and many people have attributed that, has said that the huge success of Silicon Valley being so inventive is because you cannot lock people out of industries with non-compete agreements. So there's software piracy, making unauthorized copies of proprietary software, copyright infringement, copying movies and music, corporate espionage, and then there's cyber squatting and typo squatting. You can buy domains related to a company, and then when they realize they don't own their own domain that they ought to have, they will have to pay a high fee to get the domain away from you. That's cyber squatting. And there's typo squatting, where you buy a domain that is off by one typographical error from the real company. And I saw a presentation a few years ago where a researcher made about a dozen of these names, and they got many gigabytes of confidential corporate internal mail because somebody has typed the name wrong into some mailing list and not noticed. So you will receive mail here that is really intended to be staying inside the company. Email is quite often misdirected to the wrong person, and that's why you'll find a legal statement in email saying, if you receive this and it's not really for you, you should delete it and such, because you really don't know where email is going to go. It's pretty easy for it to get misdirected from this error and for a variety of other errors. There are privacy laws which have turned out to make a lot of trouble for the United States. The main problem is that the European privacy laws are much more strict than American privacy laws, and European data in America is apparently not protected hardly at all by any privacy laws. And therefore, if a European company wants to use a wonderful American service like Google or Yahoo or Microsoft products, they have a problem trusting us to protect the privacy of their citizens up to their standards. And that's the EU Data Protection Directive. So there was a thing called Safe Harbor, which was a special law giving, specifying what American companies would have to do to be qualified to handle European data. And that was fine. But when Edward Snowden leaked out a bunch of data and showed that the NSA was in fact stealing data from inside American companies and treating the foreigners' data as not eligible for any protection at all, that ruined it. EU Safe Harbor was ended, and they spent a couple of years renegotiating a new one called Privacy Shield, which is the current one, just approved earlier this year and late last year. So it specifies the conditions under which it is legal for a European company to use American services. All right. Then there's the international cooperation on issues of cybercrime. I've been to some Secret Service events where they talk about this. In the old days, we would say if someone in another country commits a crime, it's very difficult to prosecute them. That is changing. Law enforcement agencies are cooperating a lot more across national boundaries these days, although, of course, they don't bother with this unless you've done something very bad. And then there are one of the very bad attempts to limit cryptography came in the 1990s in America when the United States government decided that anybody exporting strong cryptography should be treated as if they're exporting a dangerous weapon. So they forced all computer companies to have something called export-grade encryption, which was very weak, and we are still suffering from that because websites that wanted to be visible to legal software that was exported from America had to have a downgrade option to use miserably weak encryption, like 40-bit encryption for that purpose, and a huge legacy amount of websites now still have that feature, so there are attacks that attack the weak version of their encryption and get in. This is why a lot of people are very, very unhappy with the latest push to try to give some kind of backdoor so law enforcement can search phones, because the history of having a weak form of encryption for law enforcement purposes has been that it leads to a hole that criminals can get through later. All right, now I got some cahoots about that. We're up to 6 people, that's good. So let me turn on some sound so you can hear the glorious Kahoot music and bring it up. I'll log in and go here. And there we are. This is the first Kahoot. Okay. And my options are correct. All right. Let's see who I've got here. I've got a little window here. All right. That's 6 people. Okay. So I'll wait until I got some joiners here. Go to the kahoot.it and put in 16914. There is Rachel. Good. All right. We got 3 anyway. I think there are 3 more people that might want to join, but we'll see. Aha, a chat message. 2 more. Good. Okay. Now we're up to 5, and I have 6 people. Maybe I'm one of them, actually. All right, I think that's, I'll wait another few seconds. I think that's how many we're going to get. Let's just go ahead. Oh, there's one more message up here. Let's see. 5 is all. Okay, good. Thank you. Okay, off we go. 6 questions. Okay, what legal system requires proof beyond a reasonable doubt? Okay, of course, criminal law. I think this is popular knowledge these days. All right. So what punishment is applied simply because you broke the law, even if no harm was done? All right. That is statutory damage. The damage just from breaking the statute. Kind of theoretical, although I've certainly seen it happen in some cases I was involved in. All right, what kind of law is HIPAA? That's it, regulatory law applying to medical companies. All right, if you have a copy of a document, what is that? That's secondary evidence. This is why people keep making me sign things with pens and mail it to them even in these days. All right. So if Equifax wants to search an office computer, what do they have to do first? Right? They don't need anything. It's not the government. You're not protected from search on company equipment. They own the equipment. They can search it anytime they want. Your only defense is something like your union. It's not a matter of the law protecting you from that. All right. So what did Snowden change? Okay, that was safe harbor. The Europeans were very upset to discover that we were not protecting their data. All right, so Rachel is the winner. All right, good. Well, it's only been a half hour. I think we can do another section of this before we take a break. So let's carry on. Okay, so more laws and regulations. There's HIPAA, the one I just mentioned. The point of this was so that if people go and take a trip and then they get hit by a car, that someone in the ambulance can easily find your medical history, that they might need to know that you're allergic to a drug or something. So they wanted all health records to be on the internet. And therefore, in order to prevent confidentiality problems, this includes both making the data portable and making it secure. So it has rules that say you must put certain safeguards in place so that people don't easily steal all that medical data that's now going to be available on the internet. And the stuff that is covered by it is called protected health information. The Computer Fraud and Abuse Act protects, originally the plan was to protect government and financial computers. Unfortunately, they phrased it so that any computer that is used for interstate commerce or communication is a protected computer, and that is every computer now on the internet. So it turns out that every use of someone else's computer without their permission essentially violates the Computer Fraud and Abuse Act, and it makes almost all research of security issues illegal technically. So it's a problem. And people have been arguing about CFAA reform for a long time, and there are several egregious cases where people are punished greatly for this, and many people feel that was unfair. The Electronic Communications Privacy Act protects computer communications the way telephone communications were protected from wiretaps. It was greatly weakened by the Patriot Act, which greatly augmented the government's ability to search people's data as a response to the 9/11 attack, in the hopes that if you can search more electronic communications, you can prevent more attacks like that. The Gramm-Leach-Bailey Act requires financial institutions to protect data, and the Sarbanes-Oxley Act requires that companies account for their financial condition in more detail to try to stop another scandal like Enron, where Enron was enormously successful, stole half the entire gross domestic product from California and moved it to Texas. PCI-DSS is not a law. It is industry self-regulation. Visa, MasterCard, and other credit card companies got together and decided that the public at large is not trusting credit cards because credit card data gets stolen so much, so they will have their own security standards, which they have, and if you want to take Visa or MasterCard or other credit cards, you have to meet these rules or they will not let you do it. In fact, it is arguably ineffective. All these giant breaches you've heard were from companies that were compliant. They wouldn't have had any data otherwise. And there are a lot of exceptions and ways to ask for a delay and so on. So a lot of people argue greatly about whether PCI-DSS actually protects us well enough or not. And now there are breach notification laws. If you do get hacked and you lose data, originally only a few states like California required you to tell people, but that turned out to be a very popular idea, and now almost every state requires you to notify. This means if you have data for people all over the country, you have a very complicated legal problem of figuring out all these different laws, and there's been a lot of push to make one federal law that would subsume them all, and I don't think that happened, at least as of the last time this test was updated. A lot of people have been talking about it, but I think Congress has been unable to act to make a unified national breach disclosure law. And then there's third-party issues. We already talked about this some last time. If you hire somebody else to handle your data, now you are liable to some extent if they do the wrong thing with it. So there are a variety of agreements you can have to limit that risk. A service level agreement specifies what you expect out of them. This is typically things like percentage of uptime. Then there can be attestation, which means that the contractor you are hiring meets certain standards, and there are some clear standards here like ISO 27001 and PCI-DSS that are established standards, so you can be assured that they meet a certain standard that applies to you. You have a right, or you may negotiate a right, to do a penetration test on the company you're hiring, and so on. It is highly recommended more and more these days to check the security of products before you buy them, and to consider attacks like that Kaspersky attack that come from your supply chain. You might be writing a game, but the antivirus you use to keep your machine safe is another threat, and the companies you buy library code from and such all contribute to the final product, and you might end up getting insecure because you trusted another company's product without testing it. So there's vendor governance, which is watching to see if your vendors have the right sufficient quality to meet your standards. There are acquisitions, where you might buy a whole company, or someone else might buy a company with whom you're doing business, and that might affect their security posture. And there's the opposite, when companies are split into parts. This may result in unexpected duplication of accounts and other risks as the unified company splits into two separate groups. If you get a CISSP, you are then bound by a code of ethics. There's a whole page of documents, but here's the 4 basic canons. You protect society, you act honorably and legally like any other contractor, providing good value for money and doing what you promised to do. You provide diligent service, and you have to protect and advance the profession by giving talks and doing something above and beyond what you get paid for, the same way lawyers do a certain amount of pro bono work, and so do doctors. Security professionals are also expected to contribute some of their time and effort to helping new people and otherwise improving the profession. I had an ethics complaint posed against me back in 2011 when there was a wild and woolly fight about anonymous and other things. One guy decided to attack me, and he said that I claimed to be a security officer of the college, which I didn't. And it was a completely baseless complaint just to harass me. But the fact is, anybody can complain about you if you have a CISSP. They do not have to be a client or a CISSP themselves or anything. Anybody can file a complaint against you, and you now have to respond within 30 days or you will lose your certification. So I made it a class project, and I also got a lawyer to help me craft a good response, and they, of course, said this was nonsense and did not yank my certification. But it was pretty annoying. And that's how it works, and that can all happen to you, too, if you get a CISSP and then have somebody get mad at you. All right. Then there's governance. So you have these documents we've talked about before. You have a policy that describes in general terms the grand goal of your security posture, then procedures that say exactly what to do, and standards which specify specific products that we're going to use, and then guidelines and baselines that are discretionary, recommending the best practices and having some way to measure your posture so you can decide if you are more secure or less secure at a later time. There are things you do to protect yourself from problems with your personnel. You can train your personnel so they understand what's expected of them. You can do background checks so you don't hire personnel that have known problems. If you terminate people, you have to be careful to use a fair process, or they can sue you for wrongful termination. And you have to consider the other people you work with, like consultants and contractors. And if you outsource things, and if you move things out to other countries, you have to be careful and consider how much you really know what they're doing, and what kind of data are you trusting them with, and how do you audit their results. But of course, the attraction is you can have a much lower wage in another country if you can overcome these other concerns. Here comes a chat. Let me take a look. I see we're about to run out of time here. When I say problems, well, you mean with the outsourcing? One thing that's happened a lot with outsourcing is that people steal the data in another country. I've seen videos that show this. People are running a call center, and people are calling in, and they're taking those credit card numbers and just reselling them after work, and it's not even a crime in that country. That's one thing that can happen. Another thing that happens is once the data is out there, they can demand a pay or pay and dump it publicly. Yeah. Oh, background checks. San Francisco suffered from this greatly. We hired a network administrator here, and we did not do a background check, and it turned out he had 4 felony convictions for armed robbery, and he then made a lot of trouble for San Francisco before they found this out. Right, you can't delegate responsibility. So I'm going to have to stop the share and start it again just because I'm running out of time here. So come back in a minute, and then we'll carry on here. All right, I got to stop it.